Eviction is a legal process, and both tenants and landlords have rights and responsibilities. This video will help you understand how the process works. Please see our video on types of evictions to understand when a landlord can evict a tenant. Step 1. The landlord needs to notify the tenant they could be evicted. The notice for eviction based on non-payment of rent needs to be posted on the door of the tenant's unit. Notices for all other types of eviction need to be both posted on the door and mailed. This notice tells the tenant they are violating the lease and they need to fix it within a certain amount of time. For non-payment, the landlord needs to give 3 days. For material lease violations, 7 days. For not leaving at the end of the lease term, 30 days. Substantial lease violations are a little different. The landlord gives the tenant 3 days to move out, not fix the problem. Step 2. Once the notice period is over and the tenant has not fixed the problem, the landlord can file an eviction in court, usually the magistrate's court. The form is called a petition for restitution. Once filed, the tenant needs to be formally served with the court documents, called a summons and notice of hearing, with the petition for restitution attached. They can be delivered by a process server, a sheriff, or a person with no interest by posting on the tenant's door and mailed. The tenant can file a response to this, called an answer. Step 3. The next step is a hearing, usually set 7 to 15 days after the date of service, the date the tenant was notified. If either party does not show up, a default judgment can be issued, or a judge can dismiss the case. Step 4. Next is the court's judgment. After the hearing, the judge may either dismiss the case, meaning that the eviction has failed, and the tenant can continue to rent the unit, or grant the eviction, a judgment for restitution, a legal document that gives a sheriff the power to remove a tenant from a unit. Step 5. The last step in the process is the removal of a tenant who has not left. Remember, even after a court judgment, a landlord can't remove a tenant on their own. It's up to the landlord to notify the county sheriff, who can handle removal of the tenant as ordered by the court. Thanks for watching. For more information, contact the state court in your county.